Hello, I am Andrew Stevenson, the Secretary of the Scottish Law Agent Society, and I'm giving this talk as part of a series of talks that we're giving in relation to the legal regulation bill, which is currently progressing through the Scottish Parliament, and in relation to which we will be giving evidence to the Justice Committee in November of this year 2023. The response that the Society lodged to the bill was produced by myself together with Ken Swinton, Ian Ferguson and Darren Murdoch, who have all produced talks which should be viewed together with this one, because together the talks deal with the points raised in our response. I want to talk about something which, in our view, has not been included within the bill when it ought to have been. There actually is another point that should have been included in the bill, and it's to do with the scrutiny of the annual account of the Scottish Legal Complaints Commission. As I think Ian has already said, the issue at the moment is that the Commission is in essence vetting and approving its own budget. We take the view that that's not fair or reasonable, that there should be some outside scrutiny of the budget, and we've suggested that the Scottish Government's own auditing body look at that in the same way as they would at other public bodies. The anomaly, as it were, of the SLCC is that it doesn't run on public money, it runs on our money. But we certainly are not able to audit the accounts or approve or otherwise the budget. That rests with the Commission itself. Now, that's not to say that the Commission is in any way unreasonable or in some way acting improperly. It's just to say that transparency and accountability would tend to dictate that there should be some outside body looking at the SLCC's annual accounts. So that omission is there certainly, but the one I want to talk about is one that flows from the polluter pays principle that I think Ian mentioned in his talk. Now, as you will know if you're a solicitor, you can be the subject of a complaint to the SLCC from absolutely anyone, and the complaint can be as spurious as possible. It will be processed, and you will feel the stress and the inconvenience of that. If you are successful, you are not able to recover any costs whatsoever from the complainer, and accordingly there is simply no application within that forum of the principle known as polluter pays. As you'll know if you practice in court, there is the principle applied of polluter pays, and in fact there's also the notion that expenses will generally follow success, which is another way of saying the same thing, I suppose. But at least you know that if you're put to the trouble of defending yourself in court and you're successful, you will at least receive some kind of recompense for the time and the trouble and the inconvenience that you've had of having to defend yourself. In the SLCC forum, that doesn't happen, and we feel that's unreasonable. The fact is that the SLCC operates quasi-judicially. Nobody would really go to the bother of suing his or her lawyer in court when, if you do that, you lose. The likelihood is that you'll be found liable in expenses. If on the other hand you go to the Commission, there is no possibility of that whatsoever. We have suggested that the SLCC have a system whereby if you wish to make a complaint against a solicitor or an advocate, you should have to put up a nominal amount of money. And the amount that we've suggested has been of the order of 60 or 70 pounds. Now, it might be said, well, that's quite a lot of money to some people. Fair enough. It is less than you would pay in the Sheriff Court. It is also a matter that has been addressed in another part of the world where they do have a system whereby a complainer has to lodge a nominal fee up front. And that part of the world is the territory, the state rather, of South Australia. In Australia, in the south of Australia, strangely enough. And what has happened there has been that they had a system much like ours, and it was decided there that what would happen would be that complainers would require to lodge a levy, a refundable levy. So in other words, if they succeed in their complaint, they get their money back. South Australia, just out of interest, is not that dissimilar to Scotland. It's smaller. The population of South Australia is about 40% of ours. The Law Society there is about a third of the size of ours, and in 2021-22 the SLCC received 1,146 complaints. In South Australia, the South Australian Legal Profession Conduct Commissioner received 380 complaints, which is about a third. So they are about 40%, 33% of our size. The legislation that applies in South Australia is the Legal Practitioners Act 1981. It was amended just recently, and what the amendment did was it introduced a provision whereby the Commissioner there can fix and require the payment of fees. Now, in fairness to the SLCC, it can't do that. It doesn't have the legislative ability to do that. This bill could have given it that, but it's not there. There's no mention whatsoever of anything of that nature in the bill. In South Australia, since November 2020, anyone who wants to complain about a lawyer has to pay a sum of 110 Australian dollars, which includes tax and is about £60 sterling. So it's not that dissimilar from the amount that we were suggesting should be introduced here. In addition, we also suggested that the sum should be refundable as it is there. And significantly, the 2022 annual report of the South Australian Commissioner says that the introduction of the fee to lodge a complaint was intended to ensure that a complainant is serious about making a complaint. And that stands to reason that if you genuinely feel that you have a grievance and that you should be making a complaint about that, then you should not be deterred from doing that if you are if you're lodging a fee of that amount. On the other hand, if you're not bringing a serious complaint, then you won't want to put up £60 because the likelihood is you won't get your money back. Now, I'd said before that it might be said that £60, £70 is too much money. In other words, it would act as a deterrent against genuine complaints. Well, in South Australia, they've already thought of that, because there the commissioner is empowered to waive payment where the complainer is on benefits, or is a minor, or is in prison, or is retired, a pensioner. Also, if you've recently been in receipt of legal aid in South Australia, you are exempt as well. So the effect of this is that poverty is not a barrier to access to justice, insofar as you will not have to pay the fee, and you can simply make your complaint without having to find any sum up front. The system, however, in Australia is not primarily a fundraising matter. It is actually one where in 2022 the fees were waived for most complainers. We've looked into this. The sum that was raised was just over 12,000 Australian dollars, about £7,000. So not a huge amount of money, not in terms of the budget of the SLCC. If the SLC did likewise, given the increase, the larger number of complaints that there are in Scotland compared to South Australia, the amount would be about £20,000. Not a colossal amount of money in terms of the budget, but nevertheless it is a contribution towards its overheads and its running costs. But more importantly is the effect that it would have on deterring frivolous or vexatious complaints. It would also, of course, having that effect, would also have the effect of freeing up the resources of the Commission to deal with genuine complaints more expeditiously, more efficiently. There's also, of course, the fairness principle, going back to what I was saying earlier about polluter pays, just makes it a fairer system. So really there's no reason, we can't see any reason why that should not be introduced here. The report, the 2022 report from South Australia, goes on to say it's reasonable to assume that the introduction of the fee there has had some impact on the total number of complaints received, which of course is not entirely surprising, because anyone whose complaint is spurious will be deterred, or at least some of them will be. Some of them are bound to be. The Commissioner there in South Australia said in his report, he said that a not insignificant amount of resources of my office are applied to dealing with what are ultimately unproved or unmeritorious allegations about legal practitioners, and that this obviously impacts on the time it takes to determine genuine and reasonable complaints and investigations. So there is a public interest element to ensuring that frivolous, vexatious, opportunistic complaints are not brought, and that the requirement to find this fee should have the effect of reducing the number of complaints that fall into that category. By contrast, of course, in Scotland at the moment, we have to deal with a complaint, whether it's vexatious, frivolous or not, and doing so, as you will know if you've ever had to deal with a complaint, is an incredibly time-consuming business. It will be to your detriment, whatever the outcome of the complaint. Now this happens in two ways. Firstly, of course, as I've said, the SLCC operates entirely on funding from the profession. So the time that the Commission takes to deal with frivolous complaints is ultimately time that is paid for by lawyers. There is no contribution whatsoever from the taxpayer, there's certainly no contribution from the complainer. It's all funded by us. And that's the case regardless of how frivolous the complaint may be. So we pay for these complaints. Secondly, there is the unremunerated time and the energy and the effort that you will require to expend as the solicitor about whom the complaint has been made. And these complaints can be incredibly time consuming. We don't get paid for expending that time. It's entirely at our own expense. So we're paying for our own time, we're paying for the SLCC's time as well. On the other hand, the complainer faces no expense whatsoever, regardless of the circumstances. Complainers at the moment literally have nothing to lose. And we know, we all know that there is a potential for abuse. We can probably all, if we're required to do so, give examples of complainers who have abused the system. Not only to our detriment, but as I've said, to the detriment of genuine complainers who require to wait longer for the termination of their complaints. This isn't a case of lawyers trying to escape accountability. It's a question of putting fairness into the system. It's a question of trying to improve the efficiency and the speed of the system, and that will be to the benefit of the public, and it will be to the benefit of those who have genuine complaints. So we've suggested this fee. There is nothing whatsoever in the bill about this. We think this is a terrible omission. This is the time at which to introduce this provision, and we will maintain our position that the bill should be amended to include this mechanism for achieving fairness. Now the bill does contain measures which we think are welcome. For example, the restriction on the use of the term lawyer. We think that's a good measure. It's a mixture of good and bad, the bill. There's also another provision in there that we're not happy about, which is the naming and shaming of solicitors about whom there have been a number of complaints. We feel that this is likely to deter lawyers from taking on high-risk business or high-risk clients, because we all know that there are clients who will be quite happy to complain about their lawyer regardless of whether the lawyer's done a good job or not. We don't think it's fair that those who are the subject of complaints that are spurious or who are subject to a high number of complaints should be subjected to publicity, and we don't think that it's good for access to justice either. The last point that I want to make is one that's already been made by Darren, and it touches on the question of the regulation of our profession by the state. We think that this is a horrendous idea, and it's one that seems to have come out of nowhere, and it's completely ill-conceived, and you will have seen, if you've looked at the media, that it has come in for almost universal criticism and condemnation from not just lawyers in this country but overseas, because they recognise overseas that this is to the detriment of the reputation of the Scottish legal system. Bringing in a mechanism for government regulation of the legal profession is an appalling idea, and it is one that will diminish our standing amongst the legal systems of the world. I noticed that in July of last year, before any of this was known about any of this discussion and any of these proposals about government regulation of the legal profession were known about. The Law Agent Society had an article in the Scotsman, and it lamented the fact that in Afghanistan the progress that had been made there towards the end of the period when there was the Western occupation of the country, during that period there's been some progress made. It all unravelled overnight when the Taliban took over the country again. And I'm just noticing, I'm just looking at the article, and the heading of it, the preamble to it as it were, said that at least for a while there existed a legal profession independent of government control or influence. And it's interesting that at that time, when there was this absence of government control or influence, there was huge progress made in Afghanistan, because what happened was the parliament there established what was described as the Afghan Independent Bar Association, which was the first organisation of that nature in Afghanistan, and it acted as a regulator of advocates, lawyers, and there was a conference, I think in Kabul in July of 2008, when hundreds of Afghan lawyers got together and adopted a set of laws of the Afghan Independent Bar Association. And what happened was the Bar Association issued licenses for lawyers in accordance with these rules. The body was independent, it was non-governmental, it was self-financing, and it provided education, it provided training, public awareness programs, it confirmed the professional duties of the lawyers in Afghanistan, and they were duties that we would all recognise as lawyers everywhere. So these were, for example, avoiding conflicts of interest, maintaining client confidentiality, and there was also a provision for taking on a percentage of work on a pro bono basis. So these were all good principles that should be followed by lawyers wherever they happen to be in the world. So these were the rules that applied in Afghanistan, whilst we had the Afghan Independent Bar Association. However, when the Taliban took over the country a second time, that all vanished overnight. The Taliban attacked the head office of the Bar Association in Kabul in November 2021. It seized the association's property, it got hold of their database with details of thousands of lawyers, and what happened was the association was then merged into the Taliban Ministry of Justice. Something of an oxymoron, you might say, the Taliban Ministry of Justice. And since then, and this is the point, the regime in Afghanistan has controlled the legal profession, extinguished its independence, and the principles that were espoused by the Bar Association there, these have all been extinguished. And we see what has happened in Afghanistan since the Taliban took over as an appalling situation, particularly for women, driven out of professions, including the legal profession. Police women brutalised and murdered, women lawyers basically deprived of their livelihood and their standing as lawyers. Horrendous human rights abuses going on there. Now, nobody but a fool would say that kind of brutality would happen in Scotland. And nobody is saying that in Scotland the government would do what they do in Belarus or Russia, whereby if you act for someone that the regime doesn't like, if you act for a dissident, then you find that your license to practice is revoked, because in these countries the government controls the legal profession. they abuse that. Now, we're not saying that that would happen in Scotland, but what we are saying is that it undermines our ability in Scotland to criticise the fact that in countries such as the ones I've mentioned, the government controls the legal profession. Because what they will do, legitimately, if this bill is passed, is they will say, well, you're not in a position to criticise the fact that our government controls the legal profession here, because that's what happens in your country. And that will be true. So the point is not so much that government control of the profession here will lead to the kind of appalling atrocities that are happening in these parts of the world, but that it will undermine our standing and our ability to criticise the fact that there is government control of the legal profession in these places. And it doesn't need to be that way. At the moment, we can say our government does not control the legal profession. It doesn't control who becomes a lawyer. It doesn't control who stays being a lawyer. It doesn't control the judiciary. Now, it might be said, well, the judiciary and the legal and the profession of lawyers, as in solicitors and advocates, are distinct, but they're not distinct. Because you can't become a member of the judiciary unless you have been an advocate or a solicitor. So, in other words, if you can't get to be a solicitor or an advocate, you're certainly not going to get to be a sheriff or a judge. So, there is going to be, if this bill is passed in its present form, there will be the potential for the government to control the judiciary. There is also, of course, as has been mentioned by the other speakers, the fact that the Lord President is getting drawn in to become what would appear to be a co-regulator with the Scottish Government. That is a recipe for disaster. It's politicising the judiciary. It begs all kinds of questions, such as what happens if the Lord President disagrees with the government. It demonstrates a fundamental ignorance as to the proper role of the Lord President. The Lord President is not there to share responsibility for the regulation of the legal profession with the Scottish ministers. That is a completely misconceived idea. So we say that there should be a separation of powers. Most people understand why that's important. The executive and the judiciary should stay separate. There should not be the potential for abuse by the state of powers to interfere with the regulation of our profession of solicitors and advocates. That threat should not even be there, and it need not be there. There is no necessity whatsoever to have the role of the government there, the role of the Scottish ministers as regulators. We cannot for the life of us see what the purpose of that is, why there's that necessity. If it's being suggested that the current regime of regulation of solicitors is inadequate, well, we'd like to see why that's the case. We know that there is substantial lay representation in the structures of regulation. It's not a case of lawyers closing ranks, protecting their own backs, and to hell with the public. That's not how it works. We don't see the need for any kind of government regulation. It's not something that exists anywhere else in Western Europe. If you want to go, probably the nearest country is probably Belarus. Not exactly the kind of place we want to become. Not a great example. So, rather than emulating a former Soviet republic, we should be asserting the independence and the traditions of our legal system in Scotland, something that's existed forever as an independent system, and where we've always had a separation of powers to the benefit of all our citizens, as is the separation of power in any country. It's always to the benefit of the public, because it means that the public can go to solicitors who can then hold the state to account and uphold the rule of law. So that is the most concerning, alarming aspect of this bill, and we find it astonishing that the First Minister has said that he fundamentally disagrees with the criticism made by the judiciary, which hardly ever gets involved in commenting on the lawmaking process in Scotland. But in this case, it's exceptional circumstances here. So we are all alarmed by it, and we will maintain our opposition to this measure. So I hope that this talk and the other talks that have been given by the other three members of the Council of the Scottish Law Agent Society have been helpful. It's a measure of the concern that we have, the authors of the response have all provided talks on the bill. So we hope that it's been helpful, and we would urge everybody to voice their opposition to the proposals in the bill to infringe the separation of powers, and we hope that if everyone does that and there's sufficient public pressure on the government, then it will drop that element of the bill. But as I say, there are other provisions in there that we oppose, some that we welcome. It's a mixed bag. It's a very long bill, very complicated in some ways, but the separation of powers and the threat to that is the most important part of the bill, and we would urge everyone to take account of that and try and do whatever is necessary to stop that part of the bill going through before it becomes an act and before it becomes part of our law. And it's essentially a Pandora's box we do not want to open, and we hope that that does not happen. So thank you for listening, and goodbye.